The Honorable Jane B. Emons of Woodbridge. Good afternoon, Your Honor.
Good afternoon.
Raise your right hand, please. Do you swear or affirm, as the case may be, that the information you'll provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you. Please
Thank
be
you.
seated. And if you have a opening statement, please proceed.
Thank you very much.
Thank you.
Good afternoon, Senator Doyle, Senator Kissel, Representative Tong, Representative Rabimbus, and members of the Judiciary Committee. I'm honored to appear here before you today, and I would like to thank Governor Malloy for nominating me for reappointment as a Superior Court judge. I'm here today with my husband of 35 years. We have each served the public for more than 40 years each in our careers. By way of background, I'm the child and grandchild of immigrant Jews from Russia who left their world of oppression with nothing but the clothes on their back and whatever they could carry in a suitcase to pursue the American dream. I note this not only from a sense of pride in my heritage, but also because there exists a blog and other social media posts against me, against other judges, against some of you personally, and against other dedicated state employees that are both anti-Semitic and violent in tone. I'm saddened by those attacks, but I'm confident that they will not interfere with the important work that you are doing here today. I was appointed to the bench in May 2010. For the first 15 months, I was assigned to the Bridgeport GA handling criminal matters. Since that assignment, I have served in Stamford, New Haven, and I'm currently assigned to the Milford Courthouse, at all times as a family judge, and for all but one of those years as a presiding judge. It has been my privilege to serve the people of the state of Connecticut as a Superior Court judge. I can assure you that every day for the last 8 years, I have reflected on the enormous responsibility with which I have been entrusted. I would be grateful to this committee and our legislature if I'm permitted to continue to serve as a judge for a second term. Thank you for your time, and I would be happy to answer any questions that you have.
Thank you, Your Honor. I guess I'll just start out by asking, do you enjoy your work?
I love my work.
I must say, sitting from this vantage point and having worked on issues related to the family court system for several years now, it seems like it can be a difficult place to work. And do you still feel that way?
Yes, I do. Representative Tong, I was assigned to the family court. I was not familiar with that arena. I fell in love with it, and between then and remaining to this day, I have volunteered to take family court assignments.
Why?
I love the.
It's a sincere question.
I realize that.
Yeah.
I love the work. I love the law. I love people. I love working with people. I love helping people, and I strive to do that every day.
It seems to me, again, from my vantage point, that family court is a forum for people that are often engaged in very difficult disputes. They're very emotional disputes. They're very personal. And why do you think you're a good person for that environment?
Well, I'm fair. I'm respectful, I'm firm, I'm patient, I'm decisive, and I believe that those are the characteristics that are necessary to deal with people going through very, very, very difficult and very, very emotional times. And I believe it's our responsibility as family judges to try to help people work together to resolve their difficulties. In the event that they can't, clearly they would need a hearing of one sort or another.
So if you were here when I asked questions of Judge Koletsky earlier,
Yes.
You strike me as somebody that maybe also has an old school approach to your job.
Yes.
And clearly you have an obligation, particularly in a court like the family docket, to maintain order and to try to keep the temperature down in the room, particularly when people are emotional, when children are at stake, custody issues. And so I'm sure that it requires a great deal of patience and a firm hand, but is there a line that you can cross into being short or a bully? Understand, I'm not accusing you of being a bully. I'm just saying there's a line that one, on one side you're being tough, appropriately so, and on the other hand, maybe you're taking an inappropriately aggressive tact with the litigants. How do you police that line? Do you see that line? Tell me how you deal with that.
I certainly see the line. I must say that over the last few years, I think that the lack of civility has increased, unfortunately, in our courts and in other of our forums as well. I now, in my typical morning speech before a short calendar, remind people that we're in a real courtroom, we're not in a TV courtroom, and that we have to be respectful and professional to each other, to our opposing parties, to the court staff, and certainly to the court. That is something that I began doing just in the last 6 to 8 months. Every case is different with regard to where that line should be drawn. And there are some cases where the behavior is so disruptive and so difficult and so disrespectful that it requires a much firmer approach. There have been a couple of situations, no doubt, where I'm sure I did cross the line. I felt that it was important to maintain the decorum and order in the courtroom. Upon retrospect, I'm sure I could have done it differently.
Thank you. Chairman Kissel.
Thank you very much, Mr. Chairman. Your Honor, welcome.
Thank
Happy
you.
to have you here this afternoon.
Thank you.
A couple of things that have come to my attention and alluded to them, or actually came straight out and talked about them, and I just want to flesh them out a little bit.
Sure.
One of the things that I think we as a committee and we as a legislature can take great pride in, and it was done totally in bipartisan fashion, is that working with good folks like Chairman Tong and Ranking Member Rabimbis and Chairman Doyle, a lot of us came together, and last year we crafted a hate crimes bill. And it's my understanding, and there are people outside the legislature from outside groups that said what we passed last year was probably the best hate crimes bill in the United States. And I think that we as a state can take great pride in that. It really bothers me, and I'm wondering if you can maybe help me understand this. I understand, because I've been here long enough to see the evolution of people's angst with the family court. Some of it justified, some of it not justified, and we as a committee have tried to make strides to help reform that area in the judicial branch in working with them across the lines that separate the legislature and the judicial branch. And typically, over the years, we have seen heightened attacks on certain judges that serve in the family court. But this is the first time in my recollection that one's religion now is being targeted as well. And the history of being anti-Semitic is really bad. And I don't need to remind anybody in this room or that's watching on CTN about what took place in the world's history in the last 100, 150 years.
Yes.
Actually, way more than that. But specifically, World War II.
Thank you.
And 6 million Jews in concentration camps being systematically murdered in horrendous ways by the Nazi government. And so, I don't understand what gets in a person's head if they're disgruntled with a judge over a family court matter that would make them believe that they can go down the path of what essentially, in my view, is a hate crime. And I don't know why they're not being pursued. I understand freedom of speech, but if someone's being attacked because of their religion and because they're Jewish, that really, really upsets me.
Thank you.
That's not the Connecticut I want to live in. I don't think anybody in this room wants to live in that kind of Connecticut. So when did those attacks first come to your attention?
Well, without going into individual cases, those attacks began when I was in Stamford with a particular litigant. They were attacks on social media. They were attacks in public forums. They were attacks actually in the courtroom, on the record, in more than one instance. And for some reason, that has taken off. And clearly the blog that has been the subject of the most recent difficulty is just a very, very unfortunate, hateful, almost terroristic result of the small buildup. It's terribly troubling.
I find it more than troubling.
Thank you.
There's a part of me that doesn't understand why some of that may rise to the level of actionable crimes. I don't know. I don't know the details. I haven't seen the blogs. Just the information that I learned since your name was brought before us, as when the session began. Regarding this, have you been in touch with the administrators of the judicial branch as to whether anything is actionable, and even just a request to either Facebook or Instagram or wherever these things are? Because it's my understanding that this is a fast-moving field, and a lot of these companies have sort of been freewheeling Wild West for a long time, and now they're realizing that unless they police themselves, these things can end up with bad things happening. And so has there even been an attempt to get the anti-Semitic remarks removed from these social media areas?
I'm not sure that we've gone that far, but let me be very explicit. The judicial branch and those who were made aware of this have been extraordinarily supportive. And yes, they have taken steps, and I think that it may be just the blogs and the social media responses are still ongoing, and they're ongoing in very indiscreet ways. And I think it's a work in progress, frankly.
So we're at a public forum. I just want to communicate through you to the judicial branch. I think this needs more active follow-up. I would never begrudge anybody in this room in the state of Connecticut to put on a blog or a post, I just went to court and I have the worst judge in the world. I may disagree, but I think under our freedom of expression, I think that you could say that, and that's fair game. It's an opinion. But once you start throwing in race, ethnicity, religion, I think you're crossing a line into what I said earlier is a hate crime. And I just think that we in Connecticut should not accept that. And so I would hope that the judicial branch would look into at least maybe communicating to wherever the social media is and asking them to remove things that are offensive on that level. It's at least worth the discussion. All right, let me move on to something else that came to my attention. In speaking with you yesterday, and that's the first time we ever met, is that correct?
Yes, absolutely.
You had communicated to me, and we don't need to go into specific cases, but there was at least one instance where a disgruntled litigant contacted you in the middle of the night at your house. Would you, without naming the case or the individual, can you explain what happened there? Because again, I've had constituents that are upset with me for one reason or another. On occasion, they have come to my house, and I have to tell you, once my personal space with my children and my wife is invaded, it gets a little troubling. If someone wants to stand here in the LOB and say, Senator Kissel, you're the worst senator in the world, I guess I'm putting myself out there, and that's fair game. But once they come into the area that I consider safe for my family, then it's a little different. And so tell me what, at least, there was at least one instance, and if you could just, without naming the individuals of the case, what happened?
Yes, this is was a case where the litigant had appeared before me any number of times in Stamford. And one night at about 20 of 3, the phone rang, and the person on the other end demanded to have a conversation with me. I indicated to that person that that would not be taking place.
I'm sorry, I don't want to be rude, but at what time did that call come in?
That was at 20 of 3
In the morning.
Yes.
Okay.
Yes. I hung up the phone and said we will not be having a conversation, and put the phone, I hung it up. 2 seconds later, the phone rang a second time. My husband, I gave the phone to my husband, and I could hear the person on the other end of the phone yelling to put me back on the phone. My husband very discreetly and said that that would not take place, and that if she were to call again, we would have to call the police. I learned later that morning that this person had also called one of our children in the middle of the night, all taking place at around 3 a.m.
And I'm guessing, but I don't want to put words in your mouth, how did you feel when that took place, especially when you learned that one of your children were called in the middle of the night?
The first calls to us we found alarming. When we found out that our child had been called as well, it completely crossed the line, and we were not only alarmed, but very angry as well.
And what actually took place in response to that, as far as, I'm assuming you didn't call the police, but did you report that to the administrators of the judicial branch?
Absolutely, and they took action afterwards.
And other than what now, we've touched bases on the anti-Semitism, we've touched bases on calls in the middle of the night. Were there any other instances in your first term as a judge, serving primarily like 7/8 of your time on family court, because you love it and you still love it,
I do.
which I have to say you must be supremely dedicated in light of all of this. But were there other times, either inside the courtroom or outside, where there was words or actions or threats or anything like that, any kind of hostility?
Hostility is common. It is a discrete word to use. Hostility is common in the family court setting. Now, mind you, I can't speak for every court in the state, but I can certainly speak to Stamford, which is a very large volume courthouse. I can certainly speak to New Haven, which is, I believe, has the second largest volume in the state. And I can certainly speak to Milford. And I don't want to say it's every day, but certainly more than once or twice per week. People are belligerent, respectful. I have been sworn at. I have been given the finger by litigants. I have seen litigants engage in physical altercations between them, not necessarily in the courtroom, although we did have one of those, but outside of the courtroom. The hostility the disrespect for the system is at an all-time high.
And that sort of begs another question beyond, your personal hearing here this afternoon, because as someone who's been lucky and blessed and honored enough to serve folks in North Central Connecticut for 26 years now, and many of the judicial renominees I've seen multiple times. But as far as the family court goes, and what's amazing to me in some respects is that it's the family area. It's not even people facing criminal charges where they're going to lose their freedom for 10, 20, 30 years. I'm just not hearing this regarding other areas of our judicial system. But in the family area, each year it seems like this whole antipathy is being ratcheted up. And you're saying that the decorum in the courtroom is deteriorating at an all-time high now too. So is this because of something that's going on in our society? Is it because in that part of the state you have some litigants that have the financial wherewithal to throw everything at their spouse or to fight over a child, including the kitchen sink? Is it geographical? Does it have nothing to do with financial resources? Is it just society? What do you have any guess as to why it's moving in this direction?
This would be purely a guess. But I believe that it is a societal thing. I think that we have issues in our society with regard to civility as a whole. I think that I have spoken to people who are finding a lack of civility at schools, lack of civility in churches. And I think that it is something that society is suffering from as a whole. And I also have to say that this is the first time, certainly in my career, that I have seen, I think, an increase in untreated mental health issues, whether it be substance abuse or any type of mental health issues. And I view that from a personal standpoint, certainly, as one of the biggest issues that is affecting all of us in government.
Well, I appreciate those answers. Clearly, we've seen just horrific events take place. Church in Texas, school in Florida this week. And there's many folks that would point to guns, but there's many other folks that say that when we totally changed how we addressed mental health issues in the 70s and said that you can't institutionalize individuals, while that was very laudatory at the time because many of the institutions were just horrible, we never really made up for it on the other end. Mm-hmm. And now we're seeing the consequences of decades of just ignoring the issue. And there can be telltale signs. Also, part of it is our problem. If someone says you really should go talk to a counselor or a psychologist or a psychiatrist, unfortunately, we as a society still attach a stigma to that.
Yes.
It's better to be a drug addict than to have a mental health issue, mm-hmm. in many people's opinions. It's more forgivable to be an alcoholic than to have a deep depression, where you actually have on your permanent record that you had to seek counseling. And we see that to this day. The vice presidential nominee decades ago, Eagleton, mm-hmm. once it was determined that he had sought mental health treatment, he was essentially compelled to step away from the Democratic mm-hmm. ticket. That's not a nation that embraces treatment. That's a nation that says it embraces treatment, but you get punished if you actually go down that road. And this is a very difficult and complex issue.
Yes.
Far beyond the field for us this afternoon. I think there's going to be individuals that are going to bring out information regarding some of the cases that you've dealt with. And I actually applaud you for wanting to serve in the family court area after everything that you've been through, because unfortunately the net result of having these attacks on family court judges, sometimes warranted. I'm not painting with a broad brush whatsoever. There are reforms that were needed and continue to be needed. No two ways about it. But when it's too much on the other side as far as attacking, the net result is no one wants to be a family court judge. I mean, if you're a young, new judge, you're not going to want to go through this, because who knows what's going to happen 8 years down the road. And we can't have a system where no one wants to do the job. We can't have a society where no one wants to be a firefighter or a police officer or a teacher or a family court judge. And I don't put them all in the same category. You know, when you're in harm's way, you're in harm's way. But unfortunately, in a job where you shouldn't even have to suffer insults, let alone threats, it's now moving in that direction. So you have admitted on the record that sometimes you might have been over the top in a very difficult environment. And the first, you know, it's always good to have people accept responsibility. And so you're not saying that you're perfect and you've tried your best. It does appear to me, though, that you're handling some of the most difficult cases. And one of the things, one last point I want to get on the record, and then I'll turn it back over to my colleagues. It's also your philosophy, because you were taught this or instructed this, that when you become the presiding judge, and you have been in the past 8 years presiding judge in family matters for a number of years, that your mentors or fellow jurists had indicated to you that a good presiding judge keeps the hardest cases for him or herself.
Yes.
And so was that your philosophy, and is that part of what's sort of rolling out in front of us here, is that while you were presiding judge, if you had 10 cases in front of you and you knew that 2 of them were just going to be really, really at loggerheads, they're really upset, that when you farm them out to the other judges, those 2 are going to stay with you. Was that your philosophy?
Yes, partially. My 2 predecessors, who kind of taught me the ropes as far as presiding judge, always indicated that it was their philosophy that they would keep the hardest cases for themselves. Now, I took that philosophy and I have adhered to it for all of the time that I have served in family court. Having said that, I take my role as a presiding judge to triage the case. And by that I mean I will take a case from its inception until it goes to trial. We'll do the discovery, we'll do the day-to-day problems in that case, and get everybody working toward the notion that they have 2 options: either resolve it themselves, which is always the best way, or have a trial. At the time of trial, I believe strongly that when someone actually goes to a trial, to a hearing, ultimately disposing of that case, that there should be a clean set of eyes, a new, fresh set of eyes. So it's at that time that I would turn over the file to one of the trial judges. And I did it to protect them as well. And I think that the people who have worked with me know that and appreciate that.
Well, I appreciate your indulgence, Your Honor. I appreciate getting that information on the record. I know it doesn't go to any specific case that may be at issue this afternoon, and I know that my colleagues, many of whom may want to get into the specifics of cases. It's my understanding that if a case is on appeal, though, you're forbidden by the rules of judicial conduct to speak about those matters. And so, you know, to the extent people may stumble into a case that's on appeal, you're not going to be able to talk about that. I understand that as well.
Yes.
But again, I thought all of that information that I gleaned, I thought it was important to get that on the record this afternoon as we continue with this public hearing on your renomination. Thank you very much, Mr. Chairman.
Thank you.
Senator Gomes?
Good afternoon, Senator
Good
Gomes.
afternoon. I've sat and listened to some of the things that transpired between you and Senator Kissel, and I agree. I agree with everything you all have said, because those sort of things should never exist, not only for a judge, but for anybody else. But we are here today trying to judge who should be in our courts and who should preside over courts, and therefore we have to look at some of the things that have been put before us. I want to read off question number 21. It says, since your last appointment, has a complaint been filed against you at the Judicial Review Council? And then you marked yes. And I just wanted to comment that on a usual basis, people have checked that question off, and we have maybe 1 or 2 cases. I've counted 29.
Yes,
I've counted 29 here.
yes,
And and all of them have been dismissed.
yes.
But even if they have been dismissed, it is just an unusual amount of cases for any one judge to have filed against them. And I think we need to really get into why so many cases have been filed against you. And I have here a comment in your favor from somebody, and in the middle of what they have spoken in your favor, they have said, Judge Emons has no hesitation in speaking her mind, which some may perceive as demonstrating a negativity or bias. Now, and I've read some of these things here. Now, we talked about all the race baiting or hate crimes that we talked about before, but as I look at the comments on these cases, they are not in that vein. And so I just like to, I'm not going to be the only one that asks you questions. I'm just opening it up. And the reason why I'm opening it up, and I sat here so silently about other judges, this just smacked me in the face. 29 cases, 29 people that filed something against you. And when we usually are dealing with 1 or 2. The floor is yours.
Thank you. I want to first assure you that I take every single complaint that I receive extremely seriously. I truly take them to heart. I research them. I always try to improve. But I'd like to put this into context for you. One gentleman alone filed 9 of those complaints in the same case. 7 of those complaints were filed after I accepted his own agreement to do certain things. All 9 of these complaints were filed within, I want to say, a 4 to 5 month window. In another case, 3 people filed a complaint. Each of those 3 people were ordered to appear for a deposition that the other party sought to take. I ordered them that, yes, they would have to attend those depositions. They were not happy with that. In another case, 2 people filed a grievance in the same case. In another case, 1 person filed 2 grievances within, I think, about 6 months of each other. I'd be happy, Senator Gomes, to go through each and every one of them with you if you'd like to give you a flavor of the essence of the complaints. I can tell you that none of the complaints were, that all of the complaints were dismissed, and they were dismissed because there was no unethical conduct. The code had not been violated. The conduct had not been violated.
Well, you answered directly to me, and I think this is so unusual that other people would like to speak on it. Therefore, I'm going to defer to back to the chairman.
Certainly.
Thank you. Further questions? Representative Gonzalez.
Thank you, Mr. Chair. And first, I would like to start with the questions after Senator Kissel. he asked about a case without mentioning any name, about ringing the bell and run. If I'm not mistaken, the police report was on June 22nd, 2013. And correct me if I'm wrong, I believe that when they ask you if you did see anyone, I think that you said no. Is that was true? When they ask you if you did see anyone?
I'm not certain that I understand the case that you're referring to or the
police.
incident.
Okay, yes, about that incident.
I would ask members of the public,
I know.
Ms. Whitnam, please,
Not
I would
gonna-
ask members of the public not to approach the dais and hand documents to the members of the committee.
I'm not gonna use this, okay?
Thank you, Representative
I
Gonzalez.
did my
yeah.
own research.
Thank you, Representative
Okay.
Gonzalez. I would just ask the members of the public not to approach the members of the committee during the hearing. That's not in keeping with our rules of order on this committee. Thank you.
So, June 22nd, 2013, you claim in the Woodbridge Police Report that you did not see anyone. Is that true?
I'm not sure which police report it is that you are referring to.
June 22nd, when the bell rang?
Excuse me, Representative Gonzalez, I think it would be appropriate to show the judge and the members of the committee the document that you're referring to. Do you have copies that you want to
No.
distribute to the members here?
No, I don't, because I did this research. I went online and I did check, so I don't have that. But if she complained about the ring, I have one, but that she just gave me. I'm saying I'm not going to use this, but I think that I can use my own.
But could we stop for a second and have it copied, and so that the judge
This-
can look at it and the chairs and the ranking can look at it? Ms. Whitnam, I'm going to ask you please to sit down again.
No.
I'm going to ask you to sit down again. That's the last time I'm going to ask.
Okay. Let me then, because it's not my intention, I didn't bring any transcript, I just checked this case online, and that's why I'm saying, no, that's different.
That's different.
That's different. This is about her complaint to the police department,
Okay.
the Woodbridge Police Department. And I'm saying, is that true, that you didn't see anyone when that happened? That's all.
Yeah, the chairs and the ranking member would like to see a copy of the document as you examine the judge, and we also think it's fair for the judge to have a copy in front of her. Could we make a copy, and then could you come back to this line of questioning just in a few minutes?
This is not transcript. This is just question that I came up with the case that I saw online. I didn't make any copies of that. This was just questions. So I don't have no transcript. What I'm going to provide you guys, nothing, because I don't have no transcript. This
No,
is
but
just
you-
my question. That's it.
Do you have a copy of the police report there?
No.
Oh,
I just asking her a question.
so you're asking based on your knowledge or
Yes.
of
You
facts?
correct. That you correct. Yes.
Okay, you don't have a document in front of you that you can share?
No, sir, not on that. I have one that she just gave me, and I'm telling you that it's here, and if anybody want to see this, I haven't seen that, but if anybody want to see that,
Okay. If you're not asking about a specific document, please
Just questions.
please proceed.
okay, thank you. Thank you. Well, do you remember when you, on that case, that you complained to the police, Woodbridge Police, did you tell them that you see a person ringing the bell, or you didn't see anybody?
I recall on that evening having someone ring our doorbell at home at about 20 minutes to 1 in the morning. That was a day, the very day that the person in question was arrested, and it was also the very day that I buried my mother. Because I was not certain what this doorbell ringing could be, I did not call the police initially. About a half hour later, the doorbell rang a second time. And my husband and I, being very alarmed, there was no one at the door, being very alarmed, we called the police.
Okay. And are you aware that that person obtained her phone records via federal subpoena, which prove that she was in Manhattan on the night of June 21st through June 22nd?
I am not aware of that. I have information that is different from that.
So,
I really have to caution people from the audience, and I don't want to speculate who said what, but first of all, we have to have things on the record and be able to transcribe it. So just as a matter of decorum, I would ask the members of the audience not to shout anything while the good representative is asking questions of the judge. Thank you.
and I will say the same thing that Senator Kissel, I think is the right thing to do. I don't appreciate anybody making comments here. I think that these are questions and I will like answers, but I'm not asking anybody in the audience to respond to anything. So I also will appreciate that. Well, what I read on that case was that she subpoenaed her records, and it was a federal subpoena, and that they proved that she was not around at that time. That's what I got here. My question is, if the federal subpoena proved that she was not around, and you didn't see anybody, how this person ended up getting arrested?
I don't know that anyone was arrested.
But you just said that she got arrested.
She was
She got
arrested
arrested.
for the phone calls and the harassment prior to that. I don't believe that there was an arrest for coming to the home. If there was, I am mistaken. My recollection is that there was not.
That it was not.
Yes.
And I also have here that I think that the police they refused to arrest her. They refused to arrest her because they didn't have enough evidence that it was her at that time. Now, changing that case, I have a lot of cases, and I think that I picked maybe 4 or 5 cases. I'm going to start the West case.
Okay, Representative Gonzalez, would now be an appropriate time for the staff to hand out the copies that,
If I'm not mistaken, I think that you guys received this because he emailed this to all the members.
I guess I don't want to stop your flow, and I understand you have a lot of questions, and that's completely appropriate. It's just I know that we made copies of documents, and we were going to wait till the appropriate time to hand them out.
Right.
And I'm just wondering if now's the time.
No, not yet.
Okay.
I will, as soon as I decide, I will let you know.
Okay, now,
Okay.
my second question is, are you just asking questions that you wrote down? Because anytime you get to a document that's like a transcript or a police report or something, we can make copies of that. But if it's
Right.
just your written questions, then you can just go ahead.
Just questions.
Okay, thank you.
Okay. Okay, this is a case about a father that is raising 3 kids. And he emailed his testimony. And I'm not gonna read the whole testimony. I'm gonna read just part of that. And he said, I felt competent to represent myself in post-judgment proceeding and expected Ms. Emons to consider seriously my complaint of dishonest and unethical conduct by guardians ad litem. Instead, when I was in court, Ms. Emons essentially refused to let me speak. Instead, she deferred to the very guardian ad litem about whom I was raising serious questions, even though I have sole legal custody of the children. I'm going to start just jumping on because I don't want to read the whole thing. Ms. Emons, however, proceed by ignoring the motion filed by the parties. Instead, she required me to appear in court for weekly status conference, where she will ask guardians ad litem to resolve whatever issue Ms. Emons and the guardians ad litem thought were relevant, including which care providers should treat my children without regard to my sole legal custody and constitutional parental rights. Ms. Emons welcomed her say in testimony on her status conference and repeatedly allowed guardians ad litem to testify without being under oath. At that event, Ms. Emons also issue various verbal orders from the bench, even when no party had filed a written motion and when the parties had not been provided with any prior notice of the issue supposedly being litigated. Many of these orders were intended to punish me for challenging Ms. Emons' judicial authority, including an order that I not permit the children to leave the state of Connecticut, prohibited, and any consequences on which was to prohibit my son from attending a friend's birthday party at Yankee Stadium. And a bizarre order was posed that I pose a bond, you pose a bond of $50,000 before taking my children on vacation. This is on and on, but I'm going to stop right here. I have so many questions that I think that I'm going to stop right here, but can you explain about $50,000 bond if you want to take his kids to a birthday party?
I have no recollection of that discussion.
So you don't have no recollection on that?
I don't believe that that discussion took place.
Okay. Well, I will say to the committee that I didn't ask for any transcript because I was reading his testimony. But what I will do today or tomorrow, I'm going to try to see if I can get the transcript of this, and then we'll see if it was $50,000 to pay for a bond. So I will check into that. Now that you don't remember, I will try to see if I can find the transcript. Now, can you explain what a restraining order and what are the reasons why you will order a restraining order?
Restraining order is designed.
Excuse me, I'm sorry. Now is the time for the questions, okay? Do you have?
So, Representative Gonzalez, now you want the transcript copies handed out?
Yes,
Okay.
please.
All right, so we're just going to stand at ease while the staff hand out the copies. And again, if it's a matter that's on appeal, the judge will not be able to answer any of these questions, but we won't know that until we know which case you're asking questions on.
Okay.
Yes, and we want to make sure the judge gets a copy as well. Thank you. That's okay.
Thank you.
Okay. I will,
Hold on, one
okay.
second. Let me just ask, Your Honor, have you gotten a copy?
Yes, I did.
All right, and do you feel comfortable that you sort of have a feel for what's in there?
I do.
Okay. Representative Gonzalez?
Right. Okay, I will explain that not all these questions, I have a transcript, but on the bottom, you have here the number of the question, okay? So the first question was to explain what a restraining order is and what are the reasons why will you order a restraining order.
Let me begin by saying that with regard to this case, this is a very pending case, and the Code of Judicial Conduct will not permit me to speak to individual questions about this case.
Okay, and I didn't mention any name,
I have it right here in front of me.
the transcript.
Yes, the transcript, and it's been identified what case it is.
You know what? You're right. It was my mistake. You got me on that.
That's okay.
But that doesn't stop here anyway. Okay. These are the questions. These are the questions on that case. So I'm going to put this on the side. I'm not going to use this. Okay? I'm not going to use this. Because she's right. It's a pending case, and I know that we cannot use that. Okay. Now, but going back at the question is just a simple process. So can you explain what is the process? I'm not asking, this is just a regular question. Because if you see this, I don't have no number, I don't have no transcript. So that is a regular question. Doesn't have to do nothing with any case. Just what is the process? Can you explain?
And when you say the process, I want to be clear that you're asking, is this the process for getting a restraining
Yeah,
order?
you're correct,
Okay.
ma'am.
A judge is presented with what we call an application that is filled out by a person requesting a restraining order. A judge reviews it. A judge will either grant the restraining order or not grant the restraining order based on statutory criteria. The matter is put down, I believe that it has to be set for a hearing within a 2-week time period. Now, that hearing is granted whether or not the restraining order is granted or whether the restraining order is denied, at which time the court will have a hearing as to whether or not the restraining order should be granted.
And what is the process during they are waiting for the appeal?
When you say waiting for an appeal, I'm not sure I understand the
Okay,
question.
let's say that I appeal your decision.
Yes.
You already come up with a decision
Yes,
and not happy with the decision and appeal it.
yes.
So that means that your decision stand until they appeal it, or?
It stands until they appeal it or until someone requests that the court modify that restraining order.
Okay. Do you know how, when a parent appeal your decision to the appellate court, do you know how long it takes the appellate court to correct or to overturn the decision of any judge?
That's a better question for the appellate court than it is for me, but I do understand that it takes a long time.
Takes a long time.
Yes.
Can take a year? Or,
Yes, it can.
yeah? Okay. As a judge, are you open-minded and patient and listen to the party's position? Or do you automatically defer to the guardian ad litem?
I am open, I listen to everyone. And I allow everyone to speak, including the guardian ad litem.
Have you ever had request to remove a guardian ad litem? And have you ever done so? You ever?
I have had one request to remove a guardian ad litem, and that hearing was not in front of me.
What is the most important thing you think a judge can do for parties who appear before them?
Keep an open mind, be fair, try very, very hard to offer them some type of ability to come to their own decision, short of having a hearing.
When a parent has sole custody and decision-making authority,
I'm sorry, I didn't hear you.
when a parent
Yes.
has sole custody
Yes.
and decision-making authority, should the court ever undermine that by asking a guardian ad litem to determine which healthcare provider should be treated the children?
I can see certain circumstances where that might be appropriate.
So when it's sole custody, that doesn't mean that if I have sole custody, that doesn't mean that I will make the decision and the court will go by that?
No. I think that sole custody takes a great deal of priority. However, in a circumstance perhaps where a parent, a sole custodian, did not like what a provider was saying and opted to disregard that provider and seek another provider, and yet seek another provider, and yet seek another provider after that, I could see a situation where perhaps that issue might be brought to the court.
Well, been listening to a lot of parents and reading a lot of emails, and as far as I know, what I thought it was when a parent had a sole custody, that parent will make all the decisions, and some parents would think that it will be a violation of a parent constitutional right to parent. You know.
I'm not sure that I agree, under all circumstances.
How do you measure your level of performance and success as a judge?
I believe that I'm a very, very good judge. I believe that I have dealt with cases. This might be an appropriate time to let you know that I have disposed of almost 5,000 cases put to disposition in my term, and I have also had rulings in nearly 30,000 cases. I think that speaks for itself. These cases were disposed of or ruled on with few, if any, conflicts. And I believe that I'm a very, very good judge.
What is the role of a guardian ad litem?
A guardian ad litem's role should be to provide the child's voice, if you will, to the court.
The child's voice.
The child's voice, yes.
the guardian ad litem, as far as I know, meeting with some judges, they are the ears and the eyes of the court. The guardian ad litem, and correct me if I'm wrong, but the AMC, what is the role for the AMC, attorney for the minor child?
I believe it's a different role. The attorney for the minor child, the AMC, acts in a legal capacity on behalf of the child and has the ability to almost be, have status as a party to a case. The GAL does not have that status.
But the GAL, they are not supposed to investigate family member and the life of that child and bring the funding to the court.
I believe that a GAL may have the ability to inquire of parents and inquire of school personnel and inquire of treaters to provide information pertaining to the child to the court's attention.
All these years meeting with judges, that's the definition of guardian ad litem, supposed to investigate and bring the findings. The AMC, I thought it was the voice of the child. Where does the role of the guardian ad litem begin and end, and the role of the judge and the role of the judge begin?
I don't know that there is an end or a beginning in that type of situation.
So the role of the guardian ad litem and the role of the judge, you don't think that is like a line, like, you know, as the guardian ad litem will present, and the judge will decide. So for you, it's not a line there.
I don't see a line.
You don't see a line. Do you believe the guardian ad litem's fee are to be treated in the nature of child support?
Certainly not.
Why not?
Perhaps I'm not understanding your question.
Okay, me as a parent, I will pay the guardian ad litem thousands of dollars, and some people believe that fees are to be treated in the nature of child support. If I'm going to be fighting for my child, paying a guardian ad litem thousands of dollars, do you think they should be treated like that?
I don't believe that I understand the question, and I don't believe that I'm experienced enough with that question to answer it. I've never been faced with that question.
No. Okay, well, some lawyers believe that it should be treated that way. That's what some lawyers, I've been meeting with lawyers, and they believe that it should be treated that way. But anyway, do you believe the guardian ad litem should be present at deposition
At depositions of whom?
when their cases, let's say that as a guardian ad litem, I'm handling a case, do you think that I should be present at a deposition?
Again, I haven't been faced with that question. I would have to do a little bit of research on that one.
I might get some transcript on that too. And the reason why, because I think that that this is a very expensive. When you have a guardian ad litem involved, parents they go, they go broke paying guardians ad litems, and judges order or allow guardians ad litems to be sitting in the possession when I think that it will be more cost effective for the parents, for the parties, if they just read the transcript. But no, they allow the guardian ad litem to be sitting under this position, and I don't think, in my opinion, that is fair for the parent. When a motion is filed to remove a guardian ad litem, do you feel it is proper for judges to appoint a lawyer for a guardian ad litem at the family expenses, especially when they said that guardians ad litem has immunity.
Without a hearing, no.
Again, I think that I'm going to need a transcript for the committee. Their lawyers, they've been charging $850 an hour, and we believe that that's outrageous, paying that kind of money. Okay. Are you familiar with a party right to appeal?
With a,
They have the right to appeal.
yes, of course.
And you just explained before the process, which you really helped me understand what is the process of the appeal. You just explained it before.
If there is a ruling that is appealable, that is considered a final judgment, in most cases, that may be appealed, yes, of course, people have the right to appeal.
Okay. Have you have any of your ruling overturned upon appeal?
Yes.
How many?
I didn't really count them. There were a couple that were legal questions only. One is still pending. Actually, two the most recent two deal with the exact same issue, and the Supreme Court has taken certification on that. So it really is still up in the air, if you will, on two of them. Well, one appeal, but it affects two cases that were remanded. There were a couple of partial reversals, and there were a couple that were reversed on the law.
And what do you feel, what is your opinion when they overturn your decision?
I am bound by that. I have great respect for the appellate system, and I am bound by any of those rulings, any and all of those rulings.
Never complain about any overturned decision? Never?
I might have certain feelings, but it's not up to me to decide. It's out of my hands, and
Okay, let's discuss a little bit about status conferences.
yes.
Okay, how should status conferences be used when called by a judge?
Well, I've learned that in my 3 different locations that status conferences may be used for certain things really by jurisdiction. Some jurisdictions utilize them a great deal, some jurisdictions do not. With regard to the matter that I believe that you're concentrating on right now, and in general as well, I believe that a status conference is an effective tool that a judge has to monitor compliance in certain circumstances, to have ongoing discussions between parties in some of the most high conflict cases where parties make agreements to do certain things or behave in particular ways, and I think that they're very effective. I might also add that, generally speaking, many attorneys routinely ask for status conferences on behalf of their clients, and also, in the particular case that you're speaking about, the parties, sometimes represented and sometimes representing themselves, requested and agreed with the status conferences and requested the court's help at each and every one of these numerous status conferences. This was a very, very difficult, very painful and emotional case.
Do you believe judges should hold weekly status conferences?
If the parties request it, or if there is a reason where it's in the best interest of the child, it may be necessary. Do I believe that routinely? Certainly not.
Should both parties be required to attend status conferences?
To the extent that they are able to, absolutely.
Have you ever held status conference and not require both parties to be there?
I'm sure that I have held status conferences without parties present, but there is always someone speaking for that party, as far as I can recall.
Should litigant be put on notice what the status conference is about so they can come prepared and discuss and argue the issue?
Generally, everyone should have notice of what's coming. In the particular case that you're speaking about, I had no notice of what was going to be dealt with at the status conference. What we would do to benefit the parties was to have them come. This was a changing day-to-day set of facts with this particular family, and I felt that it was in the family's best interest to allow the family court time to go over the lists that they would bring to the status conferences every time we met. So the notice in the strict sense was not the type of notice that you're referring to. This was a request on their part for the court to give its attention to the ongoing problems in this family.
How do you ensure the parties know the specific issue to be discussed at a status conference?
Sometimes you can't,
Sometimes you can't. Why not?
because I don't know until they're there in front of me what issues have arisen during the course of the prior week.
Even if you request one?
The status conference is generally scheduled 2 to 3 weeks prior. So the parties would come 2 to 3 weeks later and bring with them issues. We would generally all agree that we would regroup on another date and discuss compliance. And because I allowed them to, each of those parties, to bring with them issues that they would wish the court to address, we did that at those status conferences.
Have you called a status conference on your own without any motion by the guardians, guardians, or party?
Yes.
And then if you call for a status conference that I asked you before, and that's why my question before, will you be sure that both parties will know the issue?
Let me respond to that, please.
Okay.
When I just answered yes, there are certain circumstances where lawyers or parties will make requests of the case flow coordinators or indicate to the case flow coordinators, we have a serious problem. We need the court's attention. We have problems, we need the court's attention because there are health situations, there are children's situations. Please advise. And I would request that the case flow coordinator set up a status conference, but it would not be initiated by me. It would be initiated by someone other than me.
Should hearsay be allowed in court?
I'm sorry?
Should hearsay, like he say, she say, should be allowed in court?
As long as it falls within one of the exceptions to the hearsay rule, yes.
So yes. So if I have a case and I will come in court and I will say, let's say I will say a lie. I said, well, she said this. Will you allow that without having any proof or?
Hearsay is generally not allowable. On the other hand, there are so many exceptions to the hearsay rule that if a statement or a question falls within one of those exceptions, yes, it would be allowable.
I always heard differently. That's why I asked the question, because I always heard the judges, they don't allow that in court. Should guardians ad litem be put under oath at these conferences?
Anyone who speaks to the court should be under oath, yes.
Should these conferences be used as a way for guardians ad litem to collect their fees?
To,
Collect their fees?
well, I think it's the only mechanism that they have to secure a court order to pay fees. So I would have to answer yes.
But as far as I know, the court, they can't act as collection agency. They are not,
They can't-
they can act as a collection agency.
Yes,
They're
you're-
not supposed to. So why then have a conferences just to collect the guardians ad litem fees?
Generally, I would not have a status conference just to elect or just to collect attorney's fees.
Okay. Can you explain in your own words what the circumstances you feel it will be appropriate for a court to restrict a parent access to his child simply because it is a high conflict case, and is no abuse or neglect?
Substance abuse under
No,
certain circumstances?
No, is neglect, abuse or neglect.
When,
Can I explain again?
yes,
Okay.
certainly.
Okay, let's say there is a case, and you consider that case a high conflict case.
Yes.
But it's no child, it's no abuse or neglect. So will you restrict the parent access to their child?
Rarely,
Rarely.
if ever, yes.
Under what circumstances do you appoint a guardian ad litem?
I think in my 7.5 years, I have only appointed one that has not been by agreement, perhaps once or twice.
Once or twice.
I will appoint a guardian ad litem when the parties agree that there should be a guardian ad litem and when they agree as to who that person should be.
Do you always agree with the opinions or recommendations from a guardian ad litem?
Absolutely not.
Since we passed the new legislation, guardians ad litem appointments, to all your court orders that appoint guardians ad litem specific the scope of the guardians ad litem duties and give a time frame as to when these duties can reasonably be expected to be completed.
I think that your question is, I want to make sure that I'm clear on it. I think that the question is, are you following the statutory guidelines that are in place?
That's correct, Your Honor.
I would like to say yes. I certainly look at every one of those forms that I require a guardian ad litem not only to fill out but complete. And I certainly make sure that that takes place. I have to say that at the beginning, when everyone was getting their feet wet with the new statute, there may have been some times where it was not adhered to precisely. but I believe that between the clerks and the courts working together, I would like to believe that it is in place and accurate.
Do you believe that parents should have the right to see the evaluations conducted on their children, psychological evaluation?
Yes,
Yes.
yes.
Should parent ever be prevented in your court from seeing those evaluations?
In ongoing criminal cases, perhaps yes. With ongoing criminal cases, perhaps yes.
Can you tell me about the state statute that we passed about the guardians ad litems? How many guardians ad litem, how many names should be in the list? The time that the parents have to make decision. Can you tell me about that?
I'm not sure what you're referencing with the
Okay.
time. No, I get the first part, with the time to make decisions. Parents, you mean making decisions as to who they should choose?
Yes.
Okay. I think that 15 names provides people a choice. I try on my own lists to have the better part of the numbers be at either a sliding scale or state rates, and I do include others who are not. I think that the parents should have a relatively shorter period of time to determine who a guardian ad litem should be.
So by the state statute, how many
Yes.
days are in the state statute that you have to follow the state statute?
I think that the maximum is 15, but I believe that it can be as few as a couple.
A couple, less
Yeah.
than 15 days?
I'm sorry?
You said less than 15 days?
I believe that is my interpretation of the statute.
Well, it's 15 days, and then you have to allow them to make decision between themselves. And if then they don't agree, then you make the decision. Okay. What is reunification therapy?
I don't know that I have a clinical definition of that, but my understanding of reunification therapy is that when a child has not seen or been in the presence of a parent for a very long period of time, there is specific therapy designed or to reintroduce, if you will, the child to the parent who they have not had access to for a period of time.
Do you ever recommend reunification therapy?
Yes.
When do you order that? When do you think that is necessary?
I order it if, for example, a parent has been incarcerated for 6 to 8 years and the mother has told the child who does not know the father that someone else is the father, and the father comes out of jail and wants to see the child. I believe that that father should see that child. So I will do it at that time. I also have done it in circumstances where there has been what we would refer to as alienation, where a parent has not seen a child for a few years, and the child, what I generally do is ask first whether or not the therapist can determine whether or not the child is, I'm at a loss of the word, whether or not this is a situation that is suitable for reunification, whether the child is resilient enough to go through reunification.
And do you think that parents should be permitted to use their insurance if such insurance cover that?
Certainly.
What is can you explain what is parental alienation?
My understanding of parental alienation is when a parent has taken the lead and really kept a child from the other parent by any number of means. It could be refusing access. It could also be a form of denigration to the point where the child wishes not to engage with that other parent.
And how do you address that?
I generally, I can't make that determination myself. I would generally engage the parties in some type of reunification therapy to see whether or not the child was resilient enough for reunification, and let the experts do their work.
When do you feel there should be supervised visitation?
There are a number of different scenarios. I think that every case is very, very different. I think that if someone is actively abusing substances, alcohol, or any type of drugs where it interferes with their ability to parent, I think that that would be an appropriate time. I think that if there is domestic violence or criminal behavior ongoing where the child's safety might be at risk, that would be a set of circumstances. And there are other circumstances where if a parent cannot conform his or her behavior to norms and the court orders, there are certain circumstances where supervised visitation might be appropriate.
And for how long you think that that is proper, supervised visitation? For how
There's-
long in a case?
No set time.
No such time. Okay. Do you feel that at some point prolonged supervised visitation is a violation of a parent constitutional right to parent?
I could foresee a situation where it might be, but I would have to generally respond no.
Have you ever heard about the AFCC?
I can't say that I have. I mean, I've heard about AFCC. I'm not sure, as I sit here, what the letters stand for. I'm sorry.
So you're telling me that you're not a member of the AFCC?
No, I am not.
Okay. When was the last AFCC sponsored event you attend?
I have no idea what the AFCC is. I don't believe that I attended any events, and if I did, please let me know, and I'm happy to answer those questions.
Okay. If a parent can't come to an agreement on a parenting plan, who should decide?
If a parent cannot come to an agreement on a parenting plan,
Right.
who should decide? I can only indicate to you how I would generally handle that. I will refer people to family relations. And when you say people, I don't know whether you're speaking about self-represented parties or parties with attorneys, or does it matter?
Okay, if let's say that I have a case and me and my husband don't agree, who should decide?
I think that if you can't decide, a judge has to decide ultimately.
A judge. So if you said there is a judge, then why do we need all these court vendors? If the judge is supposed to make a decision, that's why we're paying the judges, and we're paying a lot of money for the judges. Why we need all these court vendors?
Court vendors, I'm not sure what you're referring to.
Like different programs in the court. Let's see that. Let's start with the guardian ad litem.
Yes.
The judge is supposed to make decisions, but the judges depend usually on the guardians ad litem. They follow where most of 99% of the time they follow their recommendations, and we have other different programs, and they've been referred parents and to this program, to that program. If I'm saying that, why the judge is there to make those kind of decisions? So why we need all these other programs?
Well, I think that I'm not aware of a lot of other programs. I know that certain families have been referred to co-parent counseling. They've been referred to their GALs might weigh in on that. We have family relations that are just wonderful, and they have any number of different programs themselves to try to get people to come to agreements. I think that at the end of the day, it's imperative that people try to resolve their differences by themselves. I think that it makes them stronger. I think that it makes their decisions more important in their lives. And I would say a judge is a last resort. I still believe in mediation and trying to compromise and handle things that way.
When a psych evaluation has been conducted,
Yes.
Who better equipped to make a recommendation to the judge about that evaluation?
Well, just because a psychological evaluation is done does not mean that it goes before a judge. People will generally agree to have a psychological evaluation. The information will generally go to attorneys. It will generally go to GALs, usually by agreement of the attorneys. So it's rare, actually, that a judge will see a psychological evaluation.
So, who pay for those evaluations?
I think that the parties themselves pay for those psych evals. I have had a number of situations where the parties could not afford those psych evals, and I have asked family relations, some of the lawyers, some of the GALs to reach out to other sources to request whether or not the evaluators or the services could do it either on a pro bono basis or a reduced fee basis.
If me as a parent, I'm paying for an evaluation, do I have the right to see that evaluation? Do I have the right for a copy of that evaluation?
It's a hard question, and that's why I'm hesitating. I think ultimately, yes.
Yes. And usually those evaluation cost between $10,000 and $20,000.
I don't find that. I think it depends on which jurisdiction you're in and who is selected to do the evaluation.
Do the court recommend therapists?
I generally do not. I request that the parties either work with family relations or that they work with their own lawyers to investigate who the better of the evaluators should be.
Have you ever denied parent access to their children's psych evaluation? And I'm asking.
As a pending case, I may have. I don't recall a particular case, but when a case is pending, I probably have.
Well, me as a parent, I pay for psych evaluation, and we did have a public hearing a couple of years ago, and it was very clear that they charge between $10,000 and $20,000, and they asked for cash. That's what they did. Came here and they testify that they don't take no insurance, nothing. They just charge cash between $10,000 and $20,000. So if I am paying that kind of money, so why the court is going to deny the parent access to the psych evaluation if I'm paying for it?
In a pending case, there are other considerations to be had.
Should a guardian ad litem guardian ad litem have the right to stop a case because she's not being paid in the middle of the court? And if that guardian ad litem has the right to ask for a credit card to put on top of the table and say, I want to see the balance, do they have that right?
To your second question, I've never heard of that. I would like to say no. To your first question, I don't believe that they should have the right to, under most circumstances, to stop a case in the middle.
Okay. Do you ever have a case, or do you think that a guardian ad litem should change the outcome of an evaluation?
I'm not sure what you're referring to.
Well, based on a lot of cases, the evaluation goes first to the guardian ad litem, which I don't understand that. But I heard a lot of cases, the guardian ad litem, they alter an evaluation.
I have never heard of that.
You never heard that?
No.
Okay. Have more questions? Do you need any water or?
I would
Yeah,
love
okay.
a 5-minute break if I could have one.
No, well, you
I
can
don't
ask.
know. I'll ask
Sure, yeah,
the
yeah,
chair.
that's fine, yes. I will recess, or we'll
Thank you.
stand at ease for 5 minutes.
Thank
Thank
you
you,
very
Representative
much. Thank
Gonzalez,
you.
for being courteous.
Thank
Okay.
you.
I'm going to reconvene the Judiciary Committee meeting. Please, if you want to continue your conversations, please go outside. Okay,
Thank you.
one more try.
Thank you.
No, one more try, please. Okay. Conversations outside. Thank you. Representative Gonzalez, you have the floor.
Thank you, Mr. Chair. Let's start now with a case that is over. The
Okay.
case is finished and nothing going on with this case. So, and this the case of Mr. Mastrangelo.
Yes.
Okay. Do you recall on day 3rd of that trial, did you ask Dr. Miller, Mr. Mastrangelo, and his attorney to meet with you regarding, in your office, regarding his case?
No, I do not recall that. I would like to respond a little bit differently. I was approached by the attorneys in the case, attorneys for both sides, who asked whether or not I would be willing to have a pretrial on the Mastrangelo matter. I set aside, I don't remember if it was a half a day or a full day for those purposes, and we all met in my courtroom and had a discussion that day.
So you was not presiding the case?
Absolutely.
Right, okay. So you don't remember telling Mr. Mastrangelo and his attorney, you're not gonna get what you're looking for?
I never said that.
You never say that. Do you remember Dr. Miller in that case?
Yes, I do.
Okay. And Dr. Miller was not able to be here today, but I think that I did receive something from him.
Now, can I back up for just 1 second?
Yes.
With your last question, did we discuss those things in the pretrial? Yes. But did I ever just walk up to someone and say that? No.
And
That's
ca-
what the purpose of a pretrial is.
And can you explain a little bit about that?
I don't have a detailed recollection. I believe, I generally ask if people would like a record made of our pretrials, so I don't recall whether or not we have a transcript from that pretrial that day. I don't recall whether Mr. Mastrangelo wanted one or his counsel wanted one. There were particular things that Mr. Mastrangelo wanted, one of which was to have his, I believe that the triplets at the time were 17 years old. He requested that they be taken from the mother and sent to some camp somewhere for an extended period of time with no contact to the mother, with the mother. And I forgot there were other requirements with that as well. And I'm sure that I very directly indicated to Mr. Mastrangelo that I thought that the likelihood of that taking place would probably be not very strong.
Okay. Knowing that the case was, well, the court used to say that that was a very high conflict
Yes.
case, right?
Yes.
And you know, I don't know how many times, I think that I lost numbers, but I think that I was watching the case so many times that I never understood why the court used to say that it was a very high conflict case, because I always believe, and again, like the guardians ad litems and the AMCs and attorneys, they go as far as the judges allow that. And based on what I know on the case, it turns, you know, I think that it was, in the beginning, it was not a bad case, but with the time passed, going to court and guardians ad litems, I think it turned, based on the court, a high conflict case. But given that the case of, you know, that case, in my opinion, and what they discussed in court, it was a child abuse. And given that that you told Mr. Mastrangelo that he had no chance of winning, even though you have not heard the evidence yourself, what was the scientific and the clinical and the legal basis for that? You never, you knew about the case, because I think that a lot of people in Connecticut know about that case, but you was not the judge handling that case.
I never told Mr. Mastrangelo that he had no chance of winning. This was day 3 of 37 days in another judge's courtroom. I knew nothing about the case when I got to New Haven, but the case had pretty much had the parameters drawn by the time I got there. This was never my case. Unless I ruled on something administrative, I did not participate in this case at all, except to provide the court's time and offer a judicial pretrial in the courtroom with all of the parties, seeking a resolution.
So you was not handling the case. You never make that kind of comment to Mr. Mastrangelo. So how is that you was able to predict the outcome of a child abuse case without having heard anything of the evidence?
I never did predict the outcome in that case.
Okay. I will say again, because I didn't want to stop, the meeting here. I didn't want to cause any problems here. That's why I didn't make copies of transcript, but I know for a fact that I will get those transcripts. Now, so you was based on the case and based on the outcome and based on what Dr. Miller and his lawyer was saying, that you told them in your office, you're not gonna get what you're looking for. And then the outcome, it was exactly like you told them. Are you aware that Mr. Miller is a physician who is specialized in behavioral medicine? Are you aware that he's a member of the American Professional Society on the Abuse of Children?
He told me everything about his qualifications.
So you know all his qualifications.
Not all of them, no.
But when he was there, he explained why he was there and what was the purpose.
Yes.
And what was your opinion about Dr. Miller?
I have no opinion about Dr. Miller. He was not testifying before me.
Okay. Are you the presiding judge? You were the presiding judge of New Haven. You still?
Yes, I am not still. I'm the presiding judge in Milford
In
now.
Milford?
Yes.
Okay. Can you describe your duties as a presiding judge?
Yes, presiding judge is there to administer the docket, make sure that case management proceeds in an efficient manner, and if you're in a jurisdiction like New Haven or Stamford where you have a number of judges, you would most of the time assign trials and assign cases to those trial judges.
So you assign cases to other judges, meaning you make decision of who is going to handle the cases.
Not all the time, but
Not
yes,
all the
that's part of the responsibilities.
How do you decide which judge is going to handle, a complicated case?
It's not a matter of who will handle a complicated case. Every trial judge is qualified to handle a complicated case.
What is a pretrial? What is the purpose of pretrial?
The purpose of a pretrial is to bring both sides together, whether they're self-represented or not. There are ways of doing pretrials with both self-represented parties, or a lawyer and a self-represented party, or two lawyers. And the purpose of a pretrial is to discuss the facts of the case presented by those parties, and hope to discuss and bring the parties to some sort of an agreement on their own.
Have you ever spoken to a litigant once the trial began and you were not the judge?
I'm sorry?
Have you ever spoken to a litigant once the trial began and you were not the judge? You was not the judge handling that case.
When you say speak to a litigant, every day in every courthouse you walk through the halls and you say hello to people, or you might stop to say, how are you today? Or they might stop me and say, Judge, can I talk to you? And I generally say no. but I don't know what you mean by speak to a litigant.
Okay, let's say there is a case going on, and a person is part of that case. Do you ever stop and ask the person or ask questions or?
No, not to my knowledge.
Do you consider parental alienation to be a form of child abuse?
Yes.
Yes. And what can you do as a judge to prevent that?
I'm hesitating because my initial answer would be to get in on the ground floor and put all the stopgaps in place to make sure that it doesn't continue. Unfortunately, in so many of these cases that we see, there has been alienation over a certain course of years, and it's very, very hard to bring that back.
Do you know what the latest study show as to what the most effective way to treating severe cases of parental alienation?
No, I do not.
No, you do not. Okay. And in the courtroom, if you know there is a severe case of parental alienation, what you will do, in that moment, that you realize that something was going on and it's a parental alienation case?
My response every time that has taken place in my courtroom is to try to determine what is going on. I try to refer it to family relations. If there's a GAL in the case, refer it to the GAL to work with the treaters of that child and determine once again whether we should look right now at reunification therapy, any kind of therapy to stop the cycle.
Do you ever been interviewed or questioned by the FBI regarding family court?
No,
No.
no.
How does the best interest of the child influence a judge's decision on a daily basis?
It should be the reason behind virtually every decision that a judge makes where there's a child involved.
Do you use the standard on daily basis? Do you use it?
46B 56, I try very, very hard to do that on a daily basis, yes.
Okay. Can you list the 16 factors that make up the best interest of the children?
I have them with me.
Yeah,
Do you want me to read them
no,
into the?
no,
I-
not
no?
read that. I'm not
No, I
asking for you to
cannot.
read that.
I refer to the statute every time that I look at one of these
So
cases.
that means that when you have a case and you have, a case, that means that you always will check those 15 factors. You don't, how long you been a judge?
7.5 years.
Okay, 7.5 years.
Yeah.
So always you have to go back on the list and check
Every-
the 16 factors.
Every case is different, and yes, I check myself with reviewing the factors.
Okay. I have so many complaints against you. And it's like every day for years. And people that come here and complain about Judge Emons. And I was listening to Judge Alexander, and I'm going to quote him when they ask him, what do you bring to the bench? And he was very clear. He said, compassion, right? And I remember many years ago, I used to work in West African Court with Judge Allen W. Smith, and he used to say the same thing. He used to say, a judge has to be very clear, persistent, but a judge should have compassion for people. My opinion, that for you showing as a judge compassion to people when it's needed, I don't think that it's going to hurt you. It's going to hurt your position as a judge. We have in court every day people that goes with a lot of problems. And I agree with you that every case is different. I agree with that. I'm not a lawyer, and you have here a lot of lawyers here, and I'm not. But I listen to the people, and I want to learn, because I think that this is a problem in the court. People has a lot of problems in court, and I would like to be sure that our courts here in Connecticut, they are the best. The best. I hate and I feel sad when people said, oh my God, I have to go to court tomorrow in front of Judge Emons, and I'm so afraid, I'm scared. Or I have to go in front of this judge, and that person is like I did say before, they're sick of their stomach. And sometimes I heard a parent saying, when I have to go to court, I spend a whole week thinking about it and getting sick, and I can't function. Now, I agree that some cases, some parents, they are upset. You can justify that, and some not. I hear, I was a little bit surprised. Maybe I didn't read all the emails, but I never heard people that came here to me or send me emails. I never heard anything about being against you because your religion or whoever, your culture or whatever. I never heard that before. Never. When I receive a complaint, me personal, I think that I will say I don't want to hear it. If it comes to that position that is about religious or your ethnic or your language or whatever, I won't go for that. But I can tell you that I never heard that before. Maybe there are some things online, but I haven't seen them. But when you said before that it's a lot of increase of untreated mental cases, and it's affecting of all of us. I know cases, and I know that people, they are listening. They will agree with me when I can tell you that a lot of parents, they go to court trying to get divorced or getting divorced, and then they have to fight custody, child custody. And when they go in that court, when they start going to court, they are friends. And not because they are getting divorced, that doesn't mean that they are enemies or that they got mental problems. Now, I am not going to say that all the parents, they go to court and they have to deal with this kind of problems, like they end up homeless with no money because there are bills after bills, and they end up losing the home, jobs, everything, and they end up homeless. When I hear about these people, the way that they've been treated in court, the kind of abuse, like keep your mouth shut, I didn't order, and sometimes even when the judges ask questions and they start answering those questions, they said don't answer, because in a way they are bullying these parents, and they don't like what they are hearing. And people say when a judge has a question and the parents is ready to answer, right there from the get-go, and I got proof of that, the judges will say, keep your mouth shut, don't play with me, don't play with me. That kind of abuse is not acceptable. And that's when all these parents, after so many years going to court, they end up having, yes, mental problems because they have to deal with the judges. And not all the judges, because listen, we got judges, they are great. They are good judges. But it's like every single, position. It's like we have the good, we have the bad. The bad is giving a bad name to the good judges. When it's a good judge, and I have to fight for that good judge, listen, I'll go and I'll fight 100%, because that's what we need, good judges. We got to keep those good judges in the bench. And the bad ones, I got a problem with that, because like I'm saying, I don't think that is fair for our residents of Connecticut. They have to go to court and deal with judges like that. In a way, they are paying your salary. And for them to deal with this every day is horrible. The way that judges handle child custody and divorce, they're stalling those cases, and they stalling those cases 10, 12, 15 years. And it's unbelievable when people say, I've been in court fighting a custody case for 15 years. Some of them will tell you, I start when my daughter was born, and now my daughter is 18, and I never did have a chance to spend time with my kids, even though there is no complaint about neglect or abuse. And that's why I don't understand. When it's not a case of neglect and abuse, I will say, I don't understand what is going on. Now, when it's a case that one of the parents, is doing drugs, is drinking, or whatever he's doing, and it's bad, I do agree that it's neglect and abuse, or that person need visitation rights. Visitation, supervised visitation is horrible. Paying thousands and thousands of dollars at these parents, they don't have the money to pay for that. And I will say that I've been reading all this week, and last night I went to bed. I think it was like 2:30, and I get up 4:45 to check all these complaints about you. All these complaints about you. For many, many, many years, people that are complaining. And when they are saying that these parents are crazy or they are disgruntled parents, I really get upset, because I know, yes, they might have a few. I'm not saying no. But I can't, and I won't accept it, that all these parents, they got mental issues, or they are disgruntled parents. As when you're fighting for your son, I know that you're passionate about. And right now, people say that I'm passionate about this issue because I believe in this issue, and because I think that I have here the right to fight for those kids. They're not my kids. But guess what? I think that I have that right here as a member of this committee. So knowing that what all these parents are going through, and if you see today how many judges and referees, I think that maybe around 20 or 21. And I don't see a lot of people here complaining about the rest. I receive emails after emails after emails, but all the emails, they were complaining about you. I receive a lot of emails about attorneys supporting you. But for me, with all the respect of the attorneys, with all the respect, I'm not saying anything wrong, but with all the respect, I will say, it doesn't count for me, because those attorneys, they have to go in front of you. And those attorneys one way or the other, they know you and they deal with you. Now, on the other hand, I receive a lot of complaints about you, parent. And between all those complaints, during the whole week, maybe it was one that said, well, I've been dealing with her. And I will say that, yes, she helped me once, but at the end, she treated me like bad. I'm not going to say the word, but treat me so bad. The attitude, the way that she expressed, and the way that she asked me so many times to keep my mouth shut, the way, the demeanor. And again, that's not what we're looking for. We're looking for judges that will say, when I go out of Connecticut, I will say I come from Connecticut, and I want to feel good. They're saying that our court system is the best. And right now, with all the respect, I'm saying that's not the story here. That's not the case here in Hartford, in Connecticut. And again, we have a good ones, yes, because we have good judges here. But it's not the case. And that's what I'm looking for 11 years now, to see how we can fix the problem. And again, with all the respect, with a judge like you, the people been complaining for so many years, I don't think that with you in the court system, we're going to fix that problem. Thank you for all your answers, and thank you for being here. And my question is, the last question. Do you see the billboard that somebody paid for it and the exit 8 going to New Haven? Did you see that billboard?
I've seen a picture of it, yes.
Okay. And my question is, what do you think about that billboard, and how do you feel about that billboard?
I addressed that, I believe, in my opening statement, and I will stand with that.
And do you think that parents, they are struggling because they don't have money, they come up with a billboard to pay for a billboard like that? Do you think that those parents are crazy, or that those are disgruntled parents? They end up doing that, just calling the attention to us? What do you think about that?
I have no response.
Well, thank you.
Thank you.
And thank you for coming. Thank you very much.
Thank you, Representative. Senator Gomes.
I know you've been out there a long time, but I just have a couple of questions
course.
about one case. And
Yes.
now, I wasn't going to mention the name, but I guess it came out during your thing. It was this person, and he said his case, he says his family court case was highly publicized in Connecticut during the past 10 years. And then he's talking about he had a set of triplets. They were 16 years old. That's Mr. Mastran. What does he call him? Mastrangelo?
Yes.
Well, there's a few things that I wanted to clarify for my edification here.
Yes.
When we talked about parental alienation, that is a form of child abuse. You do recognize that, right?
Yes.
And the correct description of it is parental alienation is a process and the result of psychological manipulation of a child in order to have that child ultimately reject and cut off all ties with the targeted parent and their extended family. You do agree with that, right?
I would accept that, certainly.
Well, Mr. Mastrangelo says in January 2016, at that point, he had no involvement with the children for approximately 7 years, despite having joint legal physical custody since they were 6 years old. That's going back that 10 years. And then he says, during a break on my third day of trial, the attorneys went to case flow to schedule additional dates. Judge Edmonds overheard the attorneys scheduling more days. She asked my attorney if we were willing to meet with her along with my consultant, that Dr. Stephen Miller that they mentioned, who is supposed to have been an international expert on child abuse and parental alienation. In one comment, he says, Judge Edmonds was judging a complicated child abuse case in which she never had any evidence. Is this true? Did you have any evidence, or did you hear any evidence on this?
I
case?
did not hear evidence on this case.
So he was
Senator.
right in saying that you were judging a complicated child abuse case in which she never had any evidence.
Senator Gomes, I was in a position to pre-try the case. This was not a case that was in front of me. I extended myself as the presiding judge, knowing that this was in the middle of a trial, to get all sides together. This was also not my thought. This was brought to me by the attorneys in the case, and they asked me if I would make myself available. I did that to try to help them, all parties.
That was
reach-
approximate, go ahead, I'm sorry.
No, that's quite all right. To have them, to help them reach a resolution. That is the extent of my involvement in this case.
So that was that approximately 45-minute meeting that you had with them?
I can't tell you how long. I thought it was perhaps longer than that, but I extended myself. We met in the courtroom, and we had a very open discussion. And when I say in the courtroom, when I do these pretrials, I take my robe off. I shake everybody's hand. We have a discussion in the normal way that anyone would have a pretrial. I extended myself to Mr. Mastrangelo in the hopes that we could help both sides reach a resolution. That did not happen. It went back to Judge Kenefick, who was the trial judge. There were a total of 37 days of testimony in that case. Judge Kenefick wrote a decision that I know he read into the record. I never read or saw his decision until after that took place.
Well, he had a comment about that. I'm not gonna read that about Judge Kennedy. And then he says, by reviewing my motion, she was aware that I was requesting the only known successful remedy in severe cases of parental alienation. I'm gonna read this off, and I don't understand it myself. A 4-day intensive program along with temporary reversal of custody. Do you know what he meant by that? Or can you explain that to us?
That was explained to me by them during the pretrial. He was presenting to the court, this was his position, that his children who were 17 should be taken from their mother and sent to an intensified program. I knew that they would not have, I believe they told me that the children would not have any communication with the mother, but I believe that there were other requirements after that time. And it was a program that Mr. Mastrangelo and his attorney and his expert were advocating. It was not up to me to make the ultimate decision. We discussed it as part of a pretrial. I believe during the 37 days that he put on expert testimony about that program, and I believe that at the end of that, after hearing all the evidence, and I am not privy to the transcript in that case, to the evidence in that case, but I do know that Judge Kenefick rejected Mr. Mastrangelo's request on that issue.
He also has in here a comment that he made after that meeting that you had with the attorneys and that expert. He says here, we discussed this, and before leaving her chambers, she looked at me and said, "You will never get what you are looking for." That's when he was supposed to have made that comment.
I don't believe that those were my words. I likely did say that it was unlikely that that would take place, but that was from my perspective as a pretrial judge, given the facts at that time.
And so his understanding at that time was, what I was looking for was simply restoring my parental rights by turning to our family for court system for assistance. And then then what he came out of there, I'm just regurgitating some of the things that he came out of there with a belief. He said Judge Edmonds had the opportunity to begin to understand and ask questions about child abuse and parental alienation from a researcher, author, and leading international expert, Dr. Stephen Miller, but was unwilling to educate herself on the subject of parental alienation from this highly credible source. Parental alienation is a highly prevalent form of child abuse affecting hundreds of families in Connecticut. Would you say that any part of this statement is true about the parental alienation?
I'm not sure
Well,
that,
the
I
statement-
think I lost the point of your question.
Well, he
I
said
can-
that you weren't willing to get any education about the problem itself from this
the-
parental alienation expert.
I don't believe that that's accurate, Senator Gomes. The expert that Mr. Mastrangelo brought to the pretrial, and wanted to use pretrial time to essentially testify to me. That was not my role.
Well, I just
am-
wanted to go through this complaint that
Go
he had
ahead.
filed here against
Certainly.
you. And as a matter of fact, this letter was filed against you for today's hearing.
Yes.
Going through other things, and I'm satisfied with your, I'm not agree with them, but I'm satisfied with your answers about the letter. But have you had any cases overturned of yours through the appellate court?
Yes.
How many?
I think 6 or 7, perhaps. I have had a number of appeals, most of which were affirmed.
I recognize that through the dismissed, but what was the nature of any one or two of the cases that the appellate court overturned your case, your decisions?
The ones that I cannot discuss because they're still essentially pending deal with my granting attorney's fees in highly contentious cases, based on the notion that the cases from their inception were brought in bad faith and had no colorable claim. That is presently, and these are 2 appeals. One was appealed, one was not, but because they were remanded, they're still in the system. So whatever the Supreme Court decides on that will effectively take care of both of those. There were 3 that I can recall: the Fazio case, the Forgione case, and I believe that it was the Hornblower case, which are strict and extremely involved legal issues. The appellate court determined that in the Hornblower case, I was absolutely incorrect. I accept that. I am bound by it. The Forgione case, I think is still up for discussion because the same issue is a recurring issue, and I believe that it is at the Supreme Court, not in that case specifically, but in another case. It's at the Supreme Court. Any minute they're going to come out with a decision that may undo the reversal in that case, or that's what the lawyers are certainly hoping for. I don't know. The Fazio case, to this day, I think is still up for discussion among the attorneys, certainly. I certainly know what my obligations are as a trial judge, and I am bound by that case. And a couple of them were partial reversals, where the entire case, the substance of the case, was not, actually there were three, a more recent one. There was an issue with a restraining order that was reversed, but the custody orders in that case remained in the file. There were two others that were partial reversals where there was a contempt finding that was reversed because I had neglected to use the word willful, but the rest of the decision was upheld, and there was a similar case as well with an award of fees.
Just prior to you going to this meeting with these lawyers, that 45 minutes or so meeting,
Yes,
there's a statement here. Judge Edmonds stated that she was familiar with my case history along with its publicity. She told me that there was no reason why I shouldn't be seeing my children, as this was, after all, not a case of abuse or neglect on his part. Was that true?
probably. I don't have a recollection. I
And-
don't have an
and he still didn't-
independent recollection.
It
I'd
was.
ask you both not to speak over each
Well,
other.
I'm sorry.
That's all
I'm
right.
sorry as well.
No, that's okay. So just,
Go ahead.
Senator Gomes, if you would pose a question, and Judge Emmons, would you please respond and give each other time to get the words out? Thank you.
Go ahead.
I probably did say that because I feel that it's terrible when someone has not seen their children for a length of time. That was the whole purpose for extending everyone the pretrial, was to try to come to some agreement so that we could get back on board.
All right. With you saying that, and you probably said you probably did say that, and then he says, you said to him, you will never get what you're looking for. And what he said at the end was, what I was looking for was simply restoring my parental rights by turning to our family court system for assistance. So if you agreed with them that he should be seeing his children because it wasn't a case of abuse or neglect, then how did we come to the statement that you would never get what you're looking for? And he says all he was looking for was simply restoring his parental rights.
That is not,
That doesn't, with the correlation of the three statements, it doesn't make sense.
okay. That is not my recollection. When I entered into that pretrial, I entered into that pretrial with an understanding that both sides would engage in a discussion about formulating some type of agreement whereby we would try to put a mechanism in place to reunify Mr. Mastrangelo with his children. There is no question about that. My statement to Mr. Mastrangelo about not getting what you want, I don't believe I used those words, but I'm sure that I did tell him that it was not likely that a judge, after hearing evidence, would order 3 17-year-old children to attend this camp. I thought that that request was unreasonable. At that point, my memory is that shortly after that discussion, we realized that we were not able to come to a meeting of the minds for the purposes of furthering this pretrial discussion. Mr. Mastrangelo proceeded to Judge Kenefick's room, and 34 days later, evidence ended and Judge Kenefick wrote his decision.
Entering that camp, was
Yes.
that what he was referring to in here when he said a 4-day intensive program?
Yes.
And they were the ones that were supposed to enter into this. But I see the statements that you've made about he should have been able to see his children, and that just goes along with restoring his parental rights, because from the beginning it says here, He had no involvement with his children for 7 years, despite having joint legal physical custody since they were 6 years old. So something went on between him and his wife. If he had joint custody since they were 6 years old, going back 10 years, and now he has nothing. All of this doesn't make much sense.
I would, because I didn't try the case, I would refer you to Judge Kenefic's decision, and I would hope that it might,
I wasn't going to read this last thing about Judge Kennefitt,
Okay.
because it sounds a bit discriminatory. He said, Judge Edmonds exercised extreme poor judgment as a presiding judge in allowing an 83-year-old referee judge, Judge Kennefitt, preside over a very complicated case involving child abuse. Now, that's why I had a little bit agita trying to put that out there, since I'm about in Judge Kennefitt's category, you know. But so I'm satisfied with listening to your explanation. I'm always honest with people. I'm not saying that I would vote for you or I won't vote for you, but I'm satisfied with listening to your answers anyhow.
thank you so
Thank
much,
you.
Senator.
The Deputy Majority Leader in the House.
Thank you, Mr. Chairman. Judge Emons, good to see you.
Good to see you.
Thank you so much for taking the time to answer all of the questions here this afternoon.
Thank you.
We've heard a lot of questions about specific cases and specific instances, but I wanted to ask more about your overall philosophy. So when a case comes into your courtroom, what is the ideal outcome? Ideally, what would you like to see happen?
Ideally, I would love to see everyone who comes into the courtroom reach an agreement by any means. Certainly an agreement that is not coerced, certainly agreement that after proper canvassing, knowing that this is in truth an agreement, whether through the help of family relations, with the help of their own attorneys, with the help of any of the court support services, that is always the preferable mechanism.
And I know from reading a few of the transcripts of probably some of the more controversial cases, including some of the ones that have been referred to today, I know that one of the things that you've tried to do is ask parties to come to an agreement themselves so that you can create a court order based on their verbal agreement.
Yes.
How often are you able to do that, and how often do you have to do something outside of what they can agree to?
I mostly am able to accomplish that, especially with, I think that the lawyers work extraordinarily hard to try to resolve differences, whether there is another representative person on the opposing side or whether or not there is a self-represented litigant. I've noticed, especially over the years, that lawyers are much more willing and able, if you will, to have the conversations with self-represented parties in the hope that everyone can agree. I also, at times, will send someone back to family relations after they've already been to family relations and say, you know, let's give this another try. Let's go back to family relations and please let's work on this or this. If you're unable to do that, I'm more than happy to have a hearing. And generally, they resolve.
Do you have an estimate as to what percent of those cases are able to be resolved?
I really don't. I can only say that it is truly the parties that cannot resolve their differences. There is usually one party who is resistant to compromise, incapable of compromising, or unwilling to be reasonable.
And when it comes to cases where there's a child involved, which I imagine are probably the most contentious that you see, do you believe that it's important for both parents to be involved in their child's life? Is that your outset going forward?
The goal from the beginning is to have a child be exposed and taken care of by both parents.
Well, thank you for your answers, Judge Emons. I want to align myself with some of the comments made earlier by my colleague, Senator Kissel. As public officials and elected officials, we are often subject to some pretty awful name calling, but none to the extent of which I've seen online about you and some other family court judges. So I really appreciate the work that you do. I know it's not easy. And thank you again for taking the time to be with us this afternoon. Congratulations on your renomination.
Thank you, Representative Albus.
Thank you, Mr. Chairman.
Thank you, Representative. Further questions? Representative Bimbis.
Thank you, Mr. Chairman. And good afternoon, Your Honor.
Good afternoon.
Congratulations on your renomination. I also want to thank you for having taken the opportunity to meet with myself and the chairs even prior to today's public hearing, because that there was a great volume of testimony that was submitted. Certainly both testimony from individuals in support of your nomination as well as individuals against your nomination.
Thank you.
I think this public hearing did exactly what it's intended to do, which is to allow people from this committee to ask questions of you, ask questions certainly of specific matters that you could speak on, as well as your, let's just say, your performance on the bench, the process that certainly you have to go through on a daily basis. I think for many individuals in this committee as well, those that are practicing attorneys and not practicing attorneys, there's many attorneys here that never even have stepped foot in a family court. I think it's a learning process for everyone what that process is and what it looks like. So when you're describing a pretrial, and there's comments of evidence not being provided or certain testimony not being heard. Pretrial is not a trial. Pretrial, and as you indicated, you were actually requested in the middle of a pending trial to hear from these parties in an attempt to reach an agreement. Mm-hmm. I commend you for that, and certainly it's very rare that judges and courthouses take that, opportunity to stop a trial in order to see if a true resolution, because we all know that when things go to trial, even for a day, let alone 37 days, mm-hmm. it's not a good thing. It's not a good thing for the parties. It's not a good thing for the children. It's not a good thing for anyone, quite frankly, in that regard. So thank you for the work that you have done on the bench. And certainly we hope we'll continue to do, because I know that these issues are tough. And we try to keep an open mind always as we hear the testimony, not knowing exactly where all of this information will lead to. But I think you did, at least in my opinion, a very good job responding to the questions that I just don't see. And we're going to still hear many more people testify. But I haven't seen anything during your testimony that raises any issues for me in that regard. But certainly it is a tough area, the law, to practice in, to be a judge presiding in. So thank you for the work that you have done.
Thank you so much,
Mr. Chair.
Thank you, Representative. Any further questions? Thank you, Judge Emons. Oh, Senator Markley.
If I may, and I'm sorry, Judge, that obviously, like most of us, I've been in and out all day long, and it always concerns me that I'm retreading territory that's been well covered in the past. I just wanted to ask specifically about something that was mentioned before, which is a certain number of cases of yours that have been taken to appellate court and overturned. Not being a lawyer, not having been on this committee before this term, I'm by no means expert in what should be expected in terms of appeals or overturning of appeals. I know there's one currently before the Supreme Court that came up before. Yes. Forjohn versus Forjohn in 2015. Yes. Another one in 2016 that I think was referred to and the one that's currently before the Supreme Court.
Yes.
Do you feel that the number of cases of yours that have been overturned on appeal is, would you say it's typical of what one would expect in this kind of practice?
It's a great question, but I don't know the answer to that. I know that routinely, coming from a jurisdiction like Stanford, where virtually every decision that you could conceivably make will be appealed, you get inundated with appeals. Some are dismissed because they don't comply with some of the appellate court or Supreme Court requirements. Others may be interlocutory in nature, where an appeal is not allowed at that time. What I can say is that I'm certainly not offended by being overturned. I mean, we are always students of the law. I think that people at every level of the legal profession, judges included, will tell you that. I can tell you that a few of these cases have had very meaty legal issues to which I've given my full attention, and I don't get everything right all the time.
Thank you. I don't either, so thank you very much.
Thank you.
Obviously, you're aware that we've had an extraordinary amount of contact from people in opposition to your reappointment, which has happened occasionally, but this is it can't help but draw my attention. It's a difficult thing to pass. Difficult, I would say, almost an impossible thing for us to properly pass judgment on judges who come before us. My old colleague Doc Gunther used to vote against them as a matter of course, because he felt like there was no way to do the job adequately, and I can sympathize with that, although I think that that doesn't necessarily solve the problem either. Do you feel that the cause of this, of the number of the amount of correspondence we've received about this, simply or largely the nature of the sorts of cases that you handle, or do you have any other notion? Could you help me understand why we've heard so much about it?
I tend to be very self-reflective from a personal viewpoint, but as I've been involved in this family court scenario for the last 6 years, I have personally witnessed a yearly buildup, for lack of a better word. Every year there is more and more and more, and certain things that ramp up, using a word that was used previously with regard to the family judges. I am unfortunately the face of it this year. I believe that many of the people and much of the complaining is done without a name. It's done anonymously, so we don't know who is doing this. I can tell you that from information that I have been provided, many of these people who complain have never appeared in my courtroom, which is also very, very troubling. And I think that certainly the bar, I think that there are litigants who are on the other side of these complaints, have reached a little bit of a crescendo, and I have a feeling that this is what has happened this year. I do not want to marginalize or deflect from anything that I may have done or said as a judge. You know, I think we all have to own our behavior, our decisions, things that happen, and I think that goes for the litigants as well as the lawyers and the judges, and on and on. But I just have a sense that that is why we are where we are this year.
Do you think there's some way in which the system might be changed or improved to prevent this kind of buildup of hostility. In other words, it seems like there must be a problem if there's so much dissatisfaction, and maybe we should be getting guidance from the people who are involved in it on how this problem could be addressed to improve the system if the problem is a systemic and not a problem of individuals.
I think it needs a multidisciplinary approach, actually. I'd be happy to serve on any committee if anyone would want me to do that, but I think that we have to engage attorneys, judges, court staff, litigants, whoever it may be at any level in having a real dialogue about this issue. I think it's reached that point.
Finally, I'd have to say I've viewed with admiration your demeanor over this long questioning that has been, I know, a difficult one, and I think you've answered extraordinarily well and with perfect restraint and control. Would you say this is typical of your demeanor in the courtroom?
Yes.
Okay. Thank you very much for your time
Thank
and
you
your
very
questions.
much.
Thank you, Madam Chair, Mr. Chairman.
Thank you, Senator. Further questions? Representative Dubitsky.
Thank you, Mr. Chairman. Thank you, Judge, for coming out.
Thank
Again, don't want to retread ground that's already been well trod. I do want to ask you a bit about the complaints against you. I'll be honest, I don't think that I have seen this many complaints against any judge that's come before us in my tenure here. So I just want to make sure I understand. Do you have a copy of your application? You do?
I do.
Okay. So looking through them, they are obviously in reverse chronologic order.
Mm-hmm.
And I can, I understand those on the first page. On the second page of the attachment, there's a little section there with just a bunch of dates, and it says dismissed. I think there's
Yes.
3, 6, 9 of them.
Yes.
There's no description of any type. What's that?
What I did, as there is a paragraph there that just gives a short rendition of how the case came to Connecticut. This was a case where the wife, or the ex-wife, if you will, with 2 young children, were allowed by agreement to move and relocate from New York to Connecticut. As soon as the wife relocated to Connecticut, the case opened up in the New Haven court. We were unaware of who these litigants were. Mr. Manchanda filed paperwork, actually. He would fax things over the fax machine, and we knew that there were issues taking place. After what's required when you deal with an interstate type of case, I participated in what we call a UCCJEA conference with a judge from New York. And after about a 3 or 4 month time period, Mr. Manchanda agreed that his New York matters could be dismissed and that everything going forward would take place in Connecticut. Having said that, as I mentioned in this paragraph, I received an ex parte custody application from Mr. Manchanda's ex-wife, indicating in it that Mr. Manchanda called the Guilford police and indicated to them that he was on his way to Guilford with an armed bodyguard to retrieve his 2 young children and bring them to New Jersey for the weekend. Now, my memory, if it's correct, something like a year, 15 months perhaps, where he had not seen his children. I granted the ex parte application giving the ex-wife custody, and that began the process. Prior to coming to court, Mr. Manchanda filed 2 grievances. that he also copied to recipients such as the CIA, the FBI, the Hague Convention, the U.S. Commission Against Torture, the New Haven FBI, the New York FBI, and a number of people, some media references and people that I certainly don't know. And that was the first two. They came for a hearing. He was nothing but a consummate gentleman in the court at all times. There were never any disagreeable words. He came to an agreement with his ex-wife that he would do supervised visitation at Southern Connecticut State University to reestablish a relationship with the children. That's as far as we got. I approved and so ordered his agreement, after which 7 new grievances came, alleging things such as that his experience at Southern Connecticut was psychological and medical experimentation, Nazi-like, at Southern Connecticut State University. There are probably...
And how did that have anything to do with you?
It all had to, I mean, I was certainly part of this dialogue on his part, yes. There were Zionist references, there were Nazi-like references. He filed, I want to say I have about 2 feet of filings from Mr. Manchanda, and I also want you to know that everyone, I think, including the Judicial Grievance Committee, were also grieved.
And I assume he was pro se?
He was an attorney, actually. He was an immigration attorney from New York. He represented himself in his own litigation, yes.
Okay. With regard to, are you able to identify any of the cases on this list of complaints where the complainant was fully represented throughout
Yes.
the hearings?
Yes.
Which ones?
Let me, the first matter that appears on that first page, there was initially 2.5 years ago self-representation. Within, I want to say, a month, there was representation on the part of the grievance all the way to the end, on the part of that grievant. The second person was represented by an attorney. The third is an attorney practicing out of New Haven,
But representing
himself in his
pro se.
own litigation, yes. Mr. Lifton was self-represented. Gregory Sappos was also self-represented.
I'm sorry, which document are you looking
I'm-
at? Because I don't have...
I'm not
the-
sure which one you're looking
I
at.
don't think I have the
should be-
same, I have
Okay.
your application, the Judiciary Committee application. Do you have something that looks like this? With a attachment
You
in the
know, I
back?
have, I apologize, I have the judicial selection application.
Okay.
If you,
Representative Dubitsky, are you seeking to ask questions of Judge Emons about her reappointment nomination questionnaire?
Yes.
Okay. Why don't we give her a copy of?
Oh, that's
the
what I had
questionnaire?
asked. I thought
That's all
that
right.
she had it in front of her.
thank you, thanks so much.
Just give us
I'm
a
sorry.
second.
Thank you so much, thanks. Okay, let me, okay. All
Hold
right,
on one second, Judge Emons.
no problem.
Representative Dubitsky, do you want to, now that she has the questionnaire in front of her, do you want to pose your question again?
Yes, thank you. I just wanted to ask about which of these are pro se and which are
Yes.
represented? And you don't have to go into any detail. I'm just basically trying to get an idea of
How many?
of whether most of the complainants were pro se or if they had representation.
Okay, the first, for question 21. The first person who filed 2 grievances is pro se, it's pending in the appellate court. The next person was pro se, but part of another matter that has been discussed at length today.
Okay, and you can just
Okay.
rattle through them. I
The-
don't need any details on any of them. If you
The
could just point to
Spring-
any that had full counsel.
Spring Hollis, full counsel.
Okay.
Christopher Criscolo, through most of my involvement with the case, counsel. Myers, counsel through most of it. Puzon, counsel. John Mills, representing himself in his own litigation as a lawyer. Mr. Manchanda, the same. Mr. Lifton was self-represented. Gregory Sappos was self-represented. Mr. Marquito was represented. Sonny Kelly represented. Mr. Bueller, I think at the time was not represented, but had prior representation. Stanton was represented. Guerrero was, I think, both at different times during the pendency of that case. Mr. Broughton was self-represented. The other 3 in the next matter were all represented, although I have to say they were represented in their litigation. The plaintiff was Susan Caniff. Mr. O'Hara and Ms. Alessandroni were, I want to say at some level represented, but they spoke as if they were representing themselves. Mrs. Brennan was the mother of a litigant who was a self-represented person, and Mr. Rogue was represented.
Okay, well, thank you. Do you have any comments about whether or not more complaints are made by pro se litigants, and if so, why?
I can't say that that's the case.
Okay, so in your instance, it seems to be about half and
It
half?
seems to be about half and half, yes.
Okay. All right, well, thank you. That was my only question. I
Thank you.
appreciate your time.
Thank you.
Further questions? Thank you. Representative Gonzalez.
Thank you, Mr. Chair, for the second time. Thank you. It's going to be quick. I went to the cafeteria and I was in line and I was thinking about all my questions. And it came to me that I asked you about when do you call Mr. Mastrangelo to your office, and about, your comment to him, and you said he was in a pretrial. And it came to my attention that I was in New Haven, and for some reason, I don't know if you forgot, but then that I think that you kind of give us the wrong answer because it was a trial. It was not a pretrial. So I have to correct that because I was thinking about that when I was in line. I said, wait a minute, she answered there was a pretrial, and during the pretrial, you discussed that. And I remember when I was in line, I said, wait a minute, it was the 3rd day of the trial. I was there. It was not a pretrial, Your Honor. It was a trial, and it happened the 3rd day of the trial. And the other thing that I'm gonna question you again is about Mark Sargent. He's an attorney, and he's been fighting for those kids. And now, the ex-wife passed, and he still got the kids, but he was fighting for those kids, and it bothers me that he want to take the kids to the baseball game, to the birthday party at the Yankee Stadium, and he really said here in a bizarre order that I posed a bond of $50,000 before taking my children on vacation, and I'm gonna ask you for the second time, do you remember that $50,000 bond?
Not in the context that you're giving it to me, no.
And can you explain to me what is that was the content?
I can't. I have no recollection of talking to Mr. Sargent about a bond. I must say that I have never refused Mr. Sargent going to take his kids to a baseball game. There were a number of discussions of what those parameters were during those many, many court hearings.
Well, and my last remark, he's an attorney, and he's not here today because I think that he was another previous commitment, but he's an attorney, and this is his testimony, and my opinion is, I know him for, many years now, and a very credible person, and I don't see why he's going to write something like this if it's not true. But thank you. Thank you very much.
Thank you.
Further questions? Thank you, Your Honor.
Thank you so much, everyone.
The Honorable Robert Gennario of the great city of Norwalk. Your Honor, please raise your right hand. Do you swear or affirm, as the case may be, that the information you will provide to this committee will be the truth, the whole truth, and nothing but the truth, so help you God, or under penalty of perjury?
I do.
Thank you, Your Honor. Please be seated.
I'm going to apologize in advance. I have getting over a bit of a cough and cold. Good afternoon, Senators Kissel, Senator Doyle, Representative Tong, Representative Rubimbus, and members of the Judiciary Committee. Thank you for your patience, and thank you for the honor of appearing before you in seek of my reconfirmation. I would also like to thank Governor Malloy for nominating me for a second term as Superior Court Judge. On a personal note, it's hard for me to believe that it's been 8 years since I've been in this building, in which I hold so many fond memories and in which I have learned so much. It's a pleasure and a personal pleasure to be back here and to see so many of my friends. 8 years ago, I began my career as a Superior Court Judge in the Stamford Courthouse, and I'm still in the Stamford Courthouse. My first assignment, like that of many judges, was on the criminal side in the GA courthouse, GA courtroom in Stamford, in which I handled a variety of criminal cases, a variety of arraignments, and the like. A year later, I was transferred to the civil side, in which I conducted a number of courtside trials and jury trials. And a year after that, I was transferred to the complex litigation docket in Stamford, where I stayed in 4 years, for 4 years. As the name implies, the complex litigation docket handles a number of complex cases, things such as shareholder derivative suits, corporate dissolutions, medical malpractice, and the like. I enjoyed that assignment very much. It involved a fair amount of research and writing, and it's an assignment in which I learned a great deal. During my last year as a complex litigation judge in Stamford, I was also appointed to be the administrative judge, or AJ, in the Stamford Courthouse, for the Stamford Norwalk Judicial District. The position of local AJ is to work with the judicial branch's administration regarding what I'll call generally the business aspects of running a courthouse. This past September, I was moved from the complex litigation docket and was appointed presiding judge, or PJ, for the Stamford Norwalk